Hi, I'm Jonas Urba. I'm a New York employment lawyer here with Employment Law Reality Check. It's been about a year since I started making these videos, and today I'm doing something a little bit different. I'm going to call these Get It in Writing videos, and this is the Physicians Edition. I have quite a number of doctors who call me. Some of them are recent graduates, some are experienced long-term specialist practitioners, and others are physicians that are trying something different. And I want to talk about why it's so important to get it in writing. Young physicians sometimes will not be aware of how important it is if they stay with a certain practice and they decide to leave in a few years. They may have non-competes and non-solicitation agreements and other agreements that really kind of tie their hands. Even though in New York State, those type of agreements are generally frowned upon, it doesn't mean that a court will not take the employer's interests in mind and protect an employer's legitimate business interests against the physician. And so that's something that really needs to be taken into consideration. Experienced practitioners, specialists that have decades of experience, oftentimes have signed documents that they may not have even considered 10 or 20 or 30 years ago when they signed them. And those physicians as well can really be harmed by some of the restrictive provisions in the agreements they signed, which they may not have considered. And then we have physicians that are trying something different. I've been getting calls from physicians that are doing what I consider to be kind of alternative styles of practicing. Some of these physicians will practice at several different practices at the same time. They might have their own private practice as well as affiliations with 2 or more separate practices in hospitals, and they may not have any interrelation with one another. And then other physicians are doing telemedicine. They've decided they don't want to do the regular grind of a traditional medical practice, and so they're doing something different. In all of those situations, I always caution physicians, don't rely on just verbal agreements or verbal comments that are made to you, because most of the time those verbal comments really don't mean very much once you sign a written agreement that says anything that's not in this agreement never happened. And so don't be surprised if at one point you haven't read the entire agreement and later down the line you say, well, so-and-so told me this verbally and it's totally unenforceable. There's nothing you can do about it. Best thing to do is call some employment lawyers. Talk to us. We'll be happy to discuss with you, and then we will suggest what types of changes or what type of documents you should have in writing. So call some employment lawyers, call me. I'm Jonas Urba. I serve the entire state of New York, and I can be reached at 914-366-7366.